Good evening and welcome to our virtual Wayland Library event. Tonight we're excited to have attorney Harry S. Margolis here to speak with us about estate planning, the subject of his life's work and his new book, Get Your Ducks in a Row, The Baby Boomer's Guide to Estate Planning. Mr. Margolis has been representing seniors, individuals with special needs and their families since 1987. Since then, he and the firm have helped thousands of clients pay for long-term care, grapple with the incapacity of a family member, and plan for safe and productive futures for their children and grandchildren. Mr. Margolis' passion is explaining complex legal issues to clients in his practice, as well as to consumers through his blog and several websites listed on our calendar. For 3 decades, he served as the editor of the Elder Law Report, a monthly newsletter for attorneys, and his leadership in the field has been recognized by his peers as he was selected to be a fellow of both the National Academy of Elder Law Attorneys and the American College and Trust and Estate Council. So before we get started, I have a couple of Zoom housekeeping notes. First, we're recording this session. It will be broadcast on Waycam, our local cable access channel, so you may see your tiny video face on TV unless you turn off your video sharing. Second, Harry will be sharing some slides and giving a short presentation, and then we'll open up for questions. During this first portion, the slide portion, I recommend that you switch your view to speaker view, and also go up to under view options at the top of my screen and select view side by side. So that will give you a picture of just his slides and Harry when he starts speaking. I'll also put this info into the Zoom chat, so if you need that information again. And then finally, for the majority of the event, I'll mute everyone except for Harry to avoid excess noise. And then for the Q&A portion, if you have a question or comment, feel free to type it into the chat at any time when you think of it. Or once we get to the Q&A, feel free to raise your hand physically, or there's also a little raise hand button under the participants. Let me see. You can also always send a chat to me if you need any help. So now that we've got all that out of the way, we're ready to get started, and I'll hand it over to our speaker, Harry Margolis.
Okay, thank you, Courtney. Hello, everybody. This is a little unusual to be meeting this way rather than in person. I was expecting to be in your lovely library, which, as I told Courtney, I bicycled past twice over the last weekend, so I know where it is now. I didn't mean to bicycle by it twice, but I somehow made some wrong turns and did a big circle and ended up bicycling past it twice, which at least I knew where I was again. So we're going to talk about estate planning and really some of the basics of estate planning. And I think the coronavirus pandemic has, for at least for a lot of people, kind of focused the mind. Estate planning is one of those chores that you put off for a lot of reasons, and hopefully you're not going to. It won't matter that you put it off, and for most people, it doesn't matter so much, at least until they get into their 50s, 60s, 70s, that they put it off. But then something like this happens, so it's important for us to get this chore done and do our estate planning. It's often even more important that we get our parents to do it, because we've run into a lot of situations where people do, well, first of all, you're socially distancing, so you're not supposed to see a parent. You want to help them out, whether it's talking to medical people or helping them with their finances, and you can't get them to sign the documents to allow you to do that because they're not in place. And so it's good to get them in place first. So I'm going to talk about the basic documents and then some of the more specialized issues involving oh, I think, Michael, I think you, there, you're muted again. Okay. So then some of the other kinds of more specialized estate planning issues, and then leave really a lot of time for Q&A, because I prefer that. If you have questions, probably other people have some of the same questions, and it's a little bit easier to focus on the concrete rather than the abstract. So, so this slide just tells you a little bit more about me, but Courtney already told you enough about me, or more than enough. This is my book. Notice that at least one person has it already, which is great. And since he purchased it, It's been updated to reflect the Secure Act, which you may know about, which passed at the end of last year and changed a lot of the rules around IRAs and retirement plans. But here's the really 5 main documents that everybody should have, and we can talk about perhaps a 6th. And the first is a durable power of attorney. And how many of you have a durable power of attorney? You can raise your hand if you have it. Well, looks like I have the right audience because I didn't see a lot of hands raised. So the durable power of attorney is a document that appoints somebody else to handle your finances and your legal matters if you're incapacitated. And I've listed these documents in what I think of as the order of their importance. And the power of attorney is the most important because anybody could become incapacitated, whether temporarily or for a longer period of time, or they could be just not incapacitated physically or cognitively, but just such as in the coronavirus, you can't go out and you can't sign papers. And so to have that in place, you can have somebody you trust already ready to take over, or not necessarily take over in the sense of pushing you out, but be able to help out. And I think my misspeaking was actually important here, because the agent under power of attorney doesn't take over, doesn't push you out of being able to manage your own affairs. If you are not incapacitated, you can still do everything you've always done, and you can both act together. So that's probably the most important document, because of anybody can become incapacitated. The next most important document, I think, is the healthcare proxy, which is very similar, but it just appoints an agent to make healthcare decisions for you. But it's a little different. So a healthcare proxy, a couple things. First, you can name more than one person on a durable power of attorney to act together on your behalf. On a healthcare proxy, you can only name one person at a time. You can name a successor, but you can't name 2 people. So there's one person who ultimately makes the decision. Hopefully they'll consult with other people in your family and will follow your wishes, but it's a single agent at a time. The other difference is, while most durable powers of attorney take effect as soon as you sign them, even though they're not meant to be used until necessary, the healthcare proxy only takes effect when a doctor has determined that you are unable to make your own decisions for yourself. So that's an important distinction. So either these, actually all these documents we're going to be talking about today are revocable, so you can always change your mind and change them if you need to. The third document is the Hippa Release. And a Hippa Release is related to healthcare proxy. And if the healthcare proxy has been implemented by a doctor finding that you've become incapacitated, your agent has access to your medical records and is free to talk to medical people. But prior to that happening, there are all these privacy rules around your medical records and around healthcare information. Now, some are followed more strictly and some less. I think as it's been more years since the Hipaa law went into effect, medical people are getting a little more relaxed and talking to family members when it's deemed appropriate. But too many times we've seen medical, either the personnel or the institutions, being somewhat officious about this and not talking to family members, and even not listening to family members. There's nothing about the privacy rules that says that medical institutions and personnel can't receive information. And it can be very important if you have a parent who goes to a hospital emergency room, that the people there talk to you, that you're able to relay information, because when someone comes in that seems somewhat befuddled, the people in the emergency room don't know if this is their normal status or if they were driving, shopping, playing tennis the day before. And they also don't know, unless somebody's able to tell them, what medications the person is taking. And sometimes they don't want to be bothered, and they say, well, I can't talk to you. And as I said, that's not what Hippa says. Hippa says they can't divulge information. It doesn't say they can't receive information, but still they may hide behind it. So it's very important to have a Hippa release prepared. And unlike the healthcare proxy, you can name any number of people on the Hippa release to have access to your medical information. They just can't make decisions, but they can communicate. So what I guess is the sixth document, which I haven't entered in here as in the list, is a medical directive, which is somewhat different from the healthcare proxy and the Hippa release, but sometimes they're combined. So our healthcare proxies in our office, we have a medical directive section, which tries to give some guidance to the agent, because unless you and your agent have talked to each other, when the agent steps into your shoes and is going to make decisions on your behalf, they're really making their own decision instead of the decision that you would want. So it's important that you talk to each other, and you can provide written advice, written direction through a medical directive, and it can be something like a living will, which is really all about withdrawing life support, or it can be talk about a broad range of medical conditions and situations and what choices you would like. Most of us who are not medical professionals might not be able to anticipate what those situations would be or what decisions we'd want to make, but there are actually some workbooks out there. One is called 5 Wishes. It's pretty prevalent, that help people with this process. So you can fill out the workbook, give it to your healthcare agent or your whole family, and they'll have that to follow along. There's the columnist Ellen Goodman started a program called the Conversation Project. I think it's at theconversationproject.org, and they have tools for having a family discussion about these issues, as well as other end-of-life issues, such as, what do you want to stay at home? Do you want to move to assisted living? Those kinds of issues as well. So that's all very important. So you notice that everything we've been talking about so far is all about life, about what happens to you while you're alive. And people think about estate planning, and they think about it's all about what happens when you die. And that's important, but it's only a piece of it. And I've always felt that some of our terminology is not very good. I mean, just the name estate planning, I'm not sure how many of you feel you have an estate, but when you hear the word estate, you think of a huge mansion with a huge green lawn. And that's not what lawyers think of when they think about estate. When we say estate, it's just anything you happen to own. And so that's just one of kind of the words that I think puts people off, unfortunately. But moving on, everybody knows about a will, and people often think about that as the main estate planning document. And I think it's important, but it's become less and less important than it used to be, because the will only governs. So the will does 2 things. It names your personal representative or executor who's going to take care of things after you pass away. And it says who's going to get your stuff. And the stuff can be real estate, bank accounts, retirement accounts, your silverware, your artwork, anything else. But the reality is that it actually governs very little of that stuff, because the will only governs what's in what's called your probate estate. And your probate estate is only what you own yourself. So everything else is in your non-probate estate, or is non-probate property. So if you own something jointly, it will pass to the joint owner when you pass away. If you own something in trust, which we'll talk about in a minute, it'll pass to the named beneficiaries in the trust, or the trust may continue after you die. And if you own anything that has a beneficiary designation, it will pass automatically to the beneficiary. So that could be your retirement plans. It could be some bank accounts or investment accounts. It could be in your life insurance. So all of that is outside of the will. And a lot of people actually plan their estates to avoid probate, in which case the will might govern nothing, or might technically govern what's called your tangible personal property, just the things you can touch. But you don't really need to go, if there's no disagreement among the family members, you don't really need to go through the probate process to distribute that if everybody agrees on how it's going to be divvied up, and then it can be divvied up as they agree. But it's still important to have somebody appointed or nominated as your executor, because there's still a lot to do when someone passes away. You've got to figure out what bills are out there and pay them. If there is any probate property, you have to collect that. You have to file a final income tax return. In Massachusetts, if the estate totals more than $1 million, you have to file an estate tax return. So all these things need to happen, even if there is no probate property during that process. So that, for most people, the most important thing in your will is who you appoint. And then moving on to the irrevocable trust. This is another term that is like second nature to lawyers, and most people don't know what a trust is. And it's a little hard to explain, but a trust is a separate financial and legal entity that owns property, and the trustee is called a fiduciary, who's supposed to manage that property under the terms of the trust for the benefit of the beneficiaries. So the trust is almost a menu or recipe with instructions on how the property that's in the trust is supposed to be managed. And the trust, I often say, think of it as a box. The only thing it governs, the only thing a trust is relevant to or responsible for is whatever's put into the box. So we've had cases where clients have drafted trusts, they have not funded the trust, and the trusts are just a piece of paper because there's nothing in the trust for the instructions in the document to apply to. So when you have a trust, you need to and you want to use it, you need to retitle your assets in the trust. And that means if you have bank accounts, you need to go to the bank with the trust and say, hey, now everything needs to be transferred into the trust. If you have an account at Fidelity, you need to do the same thing. If you have a real estate, you need to sign a deed that transfers the property into the trust and name the trustees. And you can have any number of trustees on the trust. Usually it's 1, 2, or 3. I guess technically you can have more, but the more people you have, the more communication back and forth there has to be. If you have a revocable trust, you can use your own social security number on all of your accounts, so you don't have to, doesn't change your tax picture in any way while you're alive, though they're often used for estate tax planning purposes. And you can always change it. And I like revocable trusts a lot for a number of reasons. We talked about how it avoids probate, but I've also found that financial institutions often push back on powers of attorney. And they're always nervous that somebody with a power of attorney who shows up and says, I'm here now to manage my mom's assets, that they don't know if the power of attorney has been revoked since it was signed. They don't know if the woman was coerced to sign it. And they actually, I think, often break the law by not honoring powers of attorney. And we don't seem to have that problem with revocable trusts. The other thing I like about revocable trusts, to the extent we can convince clients to do this, and in full disclosure, I can't convince my mother to do this, but I think it's good to have a co-trustee, especially if you have older parents. If you have a co-trustee who's already on the account, even if they're not managing things, if the primary beneficiary becomes incapacitated, they can step in seamlessly. They're already on the account. They don't have to show their identity to the financial institutions because they've already done that. And of growing importance is it can often help protect the primary individual from scams. So as you probably know, seniors are real targets of scams, and whether it's someone, whether it's their grandchild who's purporting to be without money in in Belgrade, Serbia, or if it's or now there's a whole bunch of coronavirus scams going around. They find they're easy targets, and if you're beginning to lose a little bit of your cognitive ability, if you're isolated, it's a lot easier to become a victim of a scam. And if you have somebody who's already on your accounts, even if they're not doing the day-to-day management of those accounts, if they can see that money's all of a sudden flowing out, it's a lot easier for them to step in. So, so I like revocable trusts. So those are really the main documents, along with medical directives, that I would like to see everybody have in place. But now we can, and that's all what I call basic estate planning. But things can get more complicated. So, and I won't go into detail on these different specialty areas right now, but if you have questions about them, then we can do that. So our practice does a lot of long-term care planning, and a lot of that has to do with qualifying for Mass Health to pay for nursing home care or assisted living care, while still protecting assets for the rest of the family. So that's a more complex area. Estate tax planning can be a complex area. In most of the country, people don't have to worry about it anymore. The federal threshold for state taxes is 11.58 million this year, and for a couple, it's $23 million. So that's not our clientele. So, but in Massachusetts, as I alluded to earlier, the threshold is $1 million. And the basic estate tax plan is for a couple who have more than $1 million, is to split their assets between them. So they're each holding assets in 2 separate shares. Since we don't know who's going to pass away first, we want to set up a trust for each of them. And what the trust does is when the first spouse passes away, it shelters $1 million, so it won't be taxed when the second spouse passes away. And that's the basic plan. It's often called a credit shelter trust because it shelters that $1 million credit. And so that's very quickly the basic estate tax plan that people use. There's asset protection. Asset protection is to protect your assets from creditors usually, or also sometimes from divorce. And there's 2 kinds of asset protection. There's a kind where you have your own assets and you're trying to protect them from your own creditors or in case you get divorced, and that's much more limited. So that's harder to do. If you're going to do that, you're going to have to basically give up access to those assets yourself, or use or create what's called a domestic asset protection trust, which has been created in a lot of states. New Hampshire is one. So you can have a trust with a New Hampshire bank that could provide some of this protection. But you're getting to kind of additional costs. More usual and easier to set up is an asset protection trust that you set up for your children and grandchildren. Because it's possible to create a trust for their benefit without a lot of restrictions on how the money is spent. And it can be protected if they have financial trouble and go bankrupt, if they get sued for any reason, if they get divorced. If they passed away relatively young, you can make sure that the money stays and goes to your grandchildren rather than to the widow who knows what's going to happen in his or her life going on. So we do a lot more of those. Another issue is special needs planning. So if you have a child or grandchild with special needs, or if you get injured as an adult, often you may get a personal injury settlement, and you have funds that you would want to protect in a special needs trust for a number of reasons, probably often just for management purposes, because the person with special needs may not be able to manage them very well. But they also may be very dependent on certain benefit programs, usually SSI, supplemental security income, subsidized housing are the biggest ones, but there's also food stamps and of course Mass Health, Medicaid in other states. And often for those programs, if you own assets in your own name or if you have too much of your own income, you can't benefit from those programs. So we create these special needs trusts to shelter the assets for all these reasons. And there's different kinds depending on whether it's a parent or grandparent setting it up for the person with a disability, or the disabled person setting it up with their own money, which is more restrictive. We also sometimes have international issues. Some of the United States estate tax rules can be pretty tough on non-citizens, and depends whether they're residents or non-residents have different rules. So that can get a little more complicated. And if you have property in another country, that can make things a little more complicated. And then for some people, their pets well, if they have children, their pets may be more important to them than their children, or an equivalent, especially after the coronavirus, too much closeness, but or they may not have children. And I think a lot of people, first of all, assume they're going to outlive their pets, or figure their family will take care of them. But if you don't have family that you can rely on to do that, then it's you can create a trust for the benefit of the pet, with a person managing the funds, and the pet being the beneficiary. So those are just some of the other issues we often get into beyond the basic estate planning. And all these issues are covered in more detail in my book, Get Your Ducks in a Row. But as I said, I like answering questions, and I have a website called askharry.info, where basically I have a lot of this information up there, and but I will answer any question for no charge. Just send it in, and I'll do my best. But right now, we can open up to all your questions if you have any. And I don't know, Courtney, do you want me to stop sharing here?
That's
screen?
up to you.
You can do that.
Let me see.
Here.
So we had a couple questions in the chat. Can you see those?
Yeah, let me open that up. Okay. So do you think there's an age when you're too young to have a durable power of attorney, or is it important to have at any age? I think it's important to have at any age, just to have it. Of course, the older you get, the more important it gets. But being not wanting to be the cobbler without his own shoes, when my kids turned 18, I dragooned them into my office, and they signed durable powers of attorney. So just in case. So I think it's good to have. Let's see. How is an attorney healthcare proxy different from the one that's online, downloadable? They're usually different, but to be honest, I don't know that the difference is that important. I think use the healthcare proxy that's online. The difference in ours is we probably just have more stuff in there about what the person's rights are, the agent. We add the Hippa power in there, things like that. We do, as I said, we have the medical directive section to it. So those are some differences, and other attorneys may have other differences. But if you, as this person writes, if you go to the Massachusetts Medical Society website, you can download a form that's commonly used, often given to people when they enter the hospital to fill out. One sort of caveat and one concern I often have is that these healthcare proxies that are handed out at hospitals, you can end up having different people appointed on different ones, and have some confusion as a result. So it's I think important to if you can, just to make sure that you're consistent, or if you already have them, just let them know I already have one.
The next one, if you assign everything you own via beneficiary designations connected to accounts, do you still need a will?
So it's a good question. You probably don't. I would still say do one just in case, for the main reason, I think for two reasons. One, is to appoint the personal representative or personal representatives, which is the same as an executor. So you've chosen who's going to handle things. and there's not going to be fighting about that. And then just in case, because it may be that you've done everything you can to avoid probate and something falls through the cracks. So it's good to have the will just in case, even, and it's not that troublesome to do, even if it's not. I mean, you're not going to create a probate because you have the will, so it's good to have it.
Let's see here. Do you include, can an annuity ruin the income and make a person overqualified for Medicaid ASAP benefits?
Yes. So annuities come in a couple different forms. One is more of an investment vehicle that's sold by insurance companies, and it's a way of kind of going beyond what you can put in a retirement plan and invest things tax-free for the most part. Unlike an IRA, it's more like a Roth IRA because the money you're putting into it usually is after-tax money, but it can grow tax-deferred. And these are very complicated because they just are the way the insurance companies do them. And so they often have some guaranteed return, but then they float with the market beyond that. So some people have done very well with them because they got the guarantee when things look pretty rosy, and then things collapse, but they still have that guarantee. I've always shied away from those in terms of, I'm not a financial advisor, so I'm not really giving people advice, but just because they're so complicated, it's hard to know what people have. And I guess coming from the other end, when we've been dealing with clients who've had them, we've often had trouble getting answers. But the other kind of annuity is often called an immediate annuity, though it can also be deferred. And that's an annuity that says it's like a private pension plan. You put in a certain amount of money, and the insurance company says, we're going to pay you X amount of dollars a month for the rest, either for the rest of your life, or often for the rest of your life, but for 10 years guaranteed. And so it's an income stream. So the first annuity is an asset, and if you're applying for benefits, whether it's mass health or anything else, it's going to be counted against the asset limits. But the second annuity that's paying income is just like any other income. And if your income's too high for your mass health benefit because of that, then it's hard to get rid of it. So that can be an issue.
Okay, do you include foreign properties and financial investments in mass estate tax calculation?
So the answer is yes with financial investments and no with real estate. So that's actually a recent case that clarified that on the real estate. So for a long time, the Massachusetts Department of Revenue took the position that that out-of-state real estate was included, but then there was a Supreme Court case that overruled that, basically. So it's not included. So whether it's out of the country or just out of the state, if it's a cottage in New Hampshire, it won't be included in your on your state tax return, or it may be included. We may include it to just tell them we're not hiding anything, but with an asterisk explaining why we're not adding it into the totals. Kind of the averse of that, the reverse, is that if you own your house in Massachusetts, but you die a resident of another state, that will be included. Even though you're a non-Massachusetts resident, you will be taxed on your Massachusetts real estate when you die. Or you won't be because you'll be dead, but your state will be. So that's something that surprises people.
Okay, if you have a revocable trust and a few years later you change it, do you have to then send the new one to Fidelity Vanguard and all the places you have accounts and get the titles of the accounts updated?
No. So revocable trust you can amend, and what you say and what changes you make is really none of their business. The only time you'd have to get in touch with them and change things is if you change trustees. So if you fire one trustee and add another trustee, then you got to go through and have them go through all the paperwork to get on those accounts. Something else I think I should have mentioned on powers of attorney is I mentioned that a lot of the financial institutions are more comfortable with trust and with powers of attorney, but also a lot of financial institutions have their own power of attorney forms. So if you are at Fidelity or any of these other places and have an account, ask them for their form. They don't make them readily available. It's not something you can just search online and download. You have to have an account there and ask for it. And then you can fill that out and put your agent on the account, or at least not on the account, but at least have the power of attorney that they like already there. And so that'll make things easier in the future.
Okay, the next question says, do you have any particular advice for blended families?
Enjoy it, the blend. No, that's a great question. So as I often say, is if you have an Ozzie and Harriet family, then you may not need an estate plan so much, because the state has a plan for you called what they call the rules of intestacy, and they say who's going to get everything. But if you don't, if you've gotten divorced, if you've gotten remarried, if you have children with different parents, or children coming together, then you just really need to the planning is even just so much more important. So basically that's the first advice is plan, and I think start as early as possible. You may or may not have gotten married, but when you get committed, start thinking about this stuff, because what often happens is both a blended family that you need to think these things through, or also you often find widows and widowers getting together later in life and not talking about issues like what's going to happen when one of them becomes incapacitated, or what's going to happen. They're living in a house that's owned by one of them and that person dies, or they make no plan, which is kind of more often than not what we see, and where the assets end up, they just end up with a person who lives longer. And even though those assets might have come from the person who died first, might have built up those assets over 50 years of marriage to somebody else. So we always advise trying to talk these things through, putting it down in writing, whether or not you're going to, probably you should have an estate plan that reflects whatever you decided. Often it will involve a trust. For instance, if one spouse owns a house and they want the other spouse to be able to live in it, then they can put it in trust so the surviving spouse can live in it. But then when he or she dies, it reverts back to the first spouse's family. It's just one example. So trust can be very useful for that. But the most important thing is whatever you decide, put it in writing for a lot of reasons. First, writing it down just makes you think of more issues, because just the process does that. Two, it makes you talk stuff through. So you're going to have to write it down as something that has to be able to write down, and it forces you to talk about it. And third, none of our memories are as good as we think they are. So you could very easily have different memories of things, and it's not that one person is evil or anything. It's just you remember things differently. And then finally, you're involving your kids probably in this, and they may have a whole different idea about how things ought to be. And if one person says, well, we've talked about it, they may not believe you, but if you have it written down, they may believe you. So maybe you don't want your kids to get anything, but you better write that down.
So I'm going to pick another question that was sent to me, only just because it's also a family question. And the question is there a way to provide asset protection for your married child in the event of a divorce so that my child and grandchildren gain the stuff and the funds and it can't be split in a divorce?
Yes. So we call those family protection trusts. So if rather than leaving your assets down to your child, your daughter, say, directly, if you leave them in trust for their benefit, then it's protected. Now the problem here is that the more restrictive the trust is, or the less control your child has, the more protective it is. So the best way to do this is to have somebody else as the trustee. So if you have an institutional trustee, say a bank or a trust company or a law firm, and they're the trustee and they have discretion on how to spend the money for your daughter and your grandchildren, then that's going to be totally protected. And that is pretty bulletproof. There was a recent Massachusetts case called, with interesting names, called Pfannenstiel versus Pfannenstiel, and which basically established that, just what I said, that it's totally protected. The problem is a lot of people don't want an institutional trustee. They don't want to pay the costs. They just don't like the idea of the bureaucracy or the institution, or not having any control. So we often write our trusts in a way that may not be quite as protective, but gives the child more control. So we allow the child to be the trustee of their own trust. We allow them to manage the assets. We allow them to take out the income every year. So whether that's interest or dividends, or rent if it's real estate. But what they can't do is take out any principal. So they can't take out anything beyond the income. And if they want access to anything beyond the income, then they have to appoint an institutional trustee.
Okay, one more family question. Did you freeze, Harry? Are you still there?
Or the 15, or...
Oops, sorry.
Oh, so where did you lose me?
I hope it wasn't just my computer. Okay, I'm sorry. Did you finish answering that question?
I was just about done. So basically, I was saying that with the concept of the hybrid trust we do, the child can control the trust until they need access to principal. The Achilles heel of this trust is that the child has to follow the rules, because there's no one actually to stop them from accessing the principal except for the rules in the trust. The Fidelity has no idea that the trust says you can't access it. It just knows that the child is the trustee. So the risk is that they don't follow the rules, and if they don't follow the rules, they basically ruin the protection of the trust. Okay. So depending on how concerned you are about these issues, the more protective you can make the trust.
Okay, one more family question. Do you have any general advice for couples where one is 10 years older than the other?
I don't think I do. I mean, I guess the bigger risk there, well, first of all, there's certainly the big risk that one's going to outlive the other by a lot more years, especially if it's the guy who's the older one. I think the guy should make it very clear to the woman. I'm assuming it's a heterosexual marriage, not necessarily, but should make it very clear to the younger one that they can get remarried and do what they want, and they shouldn't feel guilty. But besides that, just my own values. But I think it's more of a question of making sure that in terms of long-term care planning, that the younger spouse is protected. Fortunately, under the Mass Health rules, that if the older spouse goes to a nursing home, there are a lot of protections for spouses in the Mass Health rules. Often we use annuities as a tool for protecting the healthier spouse. The problem with Mass Health is that while it covers nursing homes, it's less. The coverage isn't as strong for assisted living or home care. So maybe even more reason to get long-term care insurance if the family can afford it, so that you're not impoverishing the healthy spouse, who may need the money for a long time. Of course, life insurance, if you buy it when you're young enough, it can be reasonably cheap. So that can help a lot. And then finally, if the older spouse is concerned about this, my idea of remarriage and all that, then you may have more of an issue of making sure that whatever's in the estate stays in the family. So maybe more of a reason to use a trust, so that, again, the younger spouse is the beneficiary during her life and has access to the funds as needed, but it's not going to end up going to the new spouse or the new partner, whatever, with or without marriage.
Okay, a couple questions clarifying the documents that you listed. So can the durable power of attorney have a first person and then a backup person like the healthcare proxy?
Yes.
Okay. And then another, is the living will the same thing as an advance directive and a medical directive?
So an advance directive and a medical directive are the same thing. A living will is a type of medical directive or advance directive. And there's been sort of an evolution of this whole field, which kind of started with the living will, and that was really a pull the plug document, and now medical directives. I mentioned those workbooks, but everything's becoming sort of broader, and so to cover all different kinds of situations. Because like with the coronavirus, should include something saying you do want to be intubated if there's in that kind of situation. So that there's always new things that get expanded. The other thing I didn't talk about is a MOLST. I don't know if you've heard about a MOLST. It's a medical order for life-sustaining treatment. And you might have heard about DNRs, do not resuscitate. So they're similar. So a DNR is a doctor's order, so it has to be entered into your medical record, that you do not want to be resuscitated if your heart stops or if you stop breathing. And people have those in place often when they're already pretty sick. A MOLST is kind of a more expansive version of that. So something also to do with your doctor, not with your lawyer, and and you can talk about different treatment in different situations and have it as a medical order. So you can decide in advance exactly what you want. So that's an important thing in some situations as you get older, or if you're ill, basically, to talk with your doctor about.
Okay, then we have two questions about real estate. So the first is a vacation home owned in another state included in your mass estate tax calculation?
It is not, but if you do have one, it's another good reason to have a trust to hold that, because if you don't have a trust, then you may have two probates. You may have a probate in Massachusetts and probate in the other state. So, and then the other thing is, which can get complicated for families, but what's your long-range plan for the house? Do you want to stay in the family for decades and decades, or do you don't care, and you figure it's just going to be sold because your kids don't have time to go there anyway? But if you want it to be preserved, then that's something else. Another reason you may want to use a trust, and of course talk it through with your family before you do anything.
Okay, and then how should your mass primary residence be registered? In both spouses' names, right of survivorship, or what other requirements?
So unless you are doing a trust for one reason or another, then usually they're held in what's called tenants by the entirety. And that's a form of joint ownership with survivorship that's only allowed to married couples. And it's not too much different from a joint ownership, except so it's somewhat historical, but there are some creditor protections with it. So if one of the spouses gets sued, it's protected. But the other thing we do with all of our clients is we have them sign a homestead declaration that protects $600,000 of equity from creditors in any case, 600 or 500. It's one or the other, I can't remember. And if you're over 62, you can do it and protect, you can add it together. So you can have each spouse save that much of equity from creditors. Now the reality is we have all our clients sign these I've actually never seen a client who's needed it because I guess our clients haven't gone bankrupt, fortunately, and they have insurance and everything else. But it is good. Basically, it protects the house in case of bankruptcy or if you got sued or something like that. So it's a good precaution to sign a homestead declaration. The other issue I meant to mention in terms of the house in a revocable trust is if you already have a mortgage on it or a home equity loan, you can put it into the trust and that's fine. But if you want to refinance it and it's already in the trust, then the bank is going to make you take it out of the trust, put the mortgage on it, and then you can put it back in. But that's a lot of Ds to be signing and a lot of registration fees. So if our clients are going to think they're going to be refinancing in the future, then we say, well, why don't we we'll do all the documents, but why don't we hold off on the final deed into the trust?
So that's all the questions in the chat. I have a very general one, which is how do you get started? So what happens at the first appointment with your firm? What kind of documents do you need to bring? What do you have to have thought about already? Okay,
that's a good question. So we've actually just changed things during the pandemic. So for 30 years, we've been having a very comprehensive initial meeting where we send you a questionnaire which asks who's in your family, is there anyone who's ill, what are your assets. We also want some idea of your income, and what are your goals in this meeting or in your estate planning. And then we meet, and the meetings usually run about an hour and a half, and sometimes a little shorter, sometimes a little longer, to go over all this. And depending on what the client's goals are, may focus on long-term care planning or tax planning or probate avoidance or special needs planning. And we've always charged $500 for these meetings, which usually at the end of the meeting, we come up with a plan and we can quote a flat fee for implementing it. And if we get hired, we apply the $500 towards that. And that's pretty much what we've been doing, as I said, for a long time. And but what we found during the course of the pandemic is that we've been having meetings like this on Zoom and on GoToMeeting, and the meetings have been a lot shorter, a lot more to the point, and it's harder to collect the $500 virtually. So basically, we're not charging at the moment. So we're at the moment, anybody who wants to can schedule an appointment with us on Zoom or GoToMeeting. We're using both platforms, and we're still going to send out the questionnaire ahead of time because that helps us have the information we need. And then we also want to see if you have any existing estate planning documents. We want to be able to review those, so we ask you to send those in. And if you can do it virtually by email, that's the best thing. So paperless. So that's, I don't know if that answers your question.
Yes, thank you. One just popped up. What are the new 2020 RMD and QCD rules?
Oh, good question. So QCD, I'm not sure what is, to be honest, I'm not sure what QCD is. Qualified charitable deduction, I guess. So I don't know about the QCD, but I can tell you something about the RMDs.
I've unmuted the person who asked the question. Claudia, what's a QCD?
Charitable gift distributions.
Okay, that might be outside of my area of expertise, but the RMD rules have changed significantly. So at the end of they haven't changed at all for your own IRA. So let me step back a second. So some people probably know this stuff and some people don't. So if you have an IRA or a 403B or a 401k, you put money in and it won't be taxed when you put it in, but it'll be taxed when you take it out. And the whole idea is to encourage people to save money for retirement. So if you take money out before you're 59 and a half, not only do you get taxed on it, but there's an additional 10% excise tax. So they don't want you to take it out before you're 59 and a half. And then, and then they require you to start taking it out when you turn 70 and a half, or that always has been the rule. And they require you to take out a certain amount every year, and that's the RMD, which stands for Required Minimum Distribution. And that's, they have these tables based on your life expectancy, and the idea is, in theory, if you live to 107 or whatever, you're going to take it all out. So you have to take a slightly bigger percentage out every year based on your life expectancy. So the idea is, if your life expectancy is 20 years, you're supposed to take out 1/20th. And if your life expectancy is 10 years, you're supposed to take out 1/10. And so as your life expectancy gets smaller, the fraction gets bigger. So that hasn't changed. But what has changed is what happens, and was changed significantly. Sorry, it has changed in one way. They changed the year a couple ways. They changed the year, the age when you have to start taking it out, from 70 and a half to 72. So you can wait till 72 if you want to. They also changed some rules around if you're still working and you're over 72 or over, yeah, not specific on the ages, but anyways, you can keep contributing to it. So they had some restrictions on continuing to contribute to the IRA after you reached the required retirement date. Now you can still do that. But what's really changed is what happens when you inherit an IRA. So the rule had been that if you inherited an IRA, you have to begin taking withdrawals within the following year based on your life expectancy. So if you inherit an IRA and you're 20 years old and your life expectancy is 60 years, you still got to start taking the money out, but you could take out 1/60th instead of 1/10 or whatever. So you can really stretch it out. When people talk about stretch IRAs, that's what they're talking about. And the other rule has been that a spouse can always roll over the IRA to her own IRA. So the surviving spouse doesn't necessarily have to begin taking distributions the same way anyone else does if they're under 72. So that's a little different. So that's changed. They basically have gotten rid of stretch IRAs in most situations. So now, rather than being able to stretch it out for your whole life expectancy, you have to take it out within 10 years after you inherit it. So that's a big change. So that 20-year-old can't take out just 1/60th and then 1/59th and 1/58th until she's 30. She's going to have to take it all out by the time she's 30, and pay the taxes on it. So that's the problem with it. And a lot of this, it's not true with a 20-year-old, but say it's a 40-year-old, they may be taking it out while they're in a pretty high tax bracket, instead of taking it out when they're retired and in a relatively low tax bracket. So that's made it a lot harder. Now there are a few exceptions to this. So if you're, and I'm still, I learned it all, and then I haven't thought about it since coronavirus hit. So I might not remember all this all exactly, but I have it on my Ask Harry site. So if you're under 18, you can use the old life expectancy tables until you're 18. I think it's 18. And that 18 can be extended to, I think, 26 if you're still in school. So presumably, if you're young and you're still in school, then you can, again, take out that small portion each year until you get to be 26, and then you got 10 years from there. Might be 25, one or the other. So they have that. Spouses can still roll these over to their own IRAs. So that wasn't restricted. And then if the beneficiary is disabled, they can use their life expectancy table. They don't, the 10-year rule doesn't apply to them. Now, this gets really complicated if you have the money going to a trust. Because, and if anyone who has a special needs trust already set up that was going to receive IRA money needs to have it reviewed. Because they have this whole concept of designated beneficiaries. Now they have something called a qualified designated beneficiary. And these people who are disabled are qualified designated beneficiaries. But again, it's getting too complicated. I won't go into the trust stuff. But the one other qualified designated beneficiary is someone who's less than 10 years younger than the decedent. So if the decedent was 80 and it's going to someone who is 75, they can also use their own life expectancy tables still. So it's probably more than you wanted to know, but they've made, it seems like every time they do something, they make it more complicated.
And then the follow-up question, what about Roth IRAs and RMD? No time limit there?
No, I believe not. I've never learned a whole lot about Roth IRAs, because I guess I've always had the opinion that they just made everyone's life is more complicated. But I think that's right.
Okay.
And again, there's no tax when you take it out, so it doesn't matter as much.
Does anyone have any more questions? You can unmute yourself. You can type it in the chat. I am going to put Harry's various blogs and websites into the chat if you didn't get a chance to grab those from our website. The first one is where to get his book.
Here, I can share again.
Yeah, go for it.
That'll work.
There we go. Oh, there we go.
Yeah. If you have questions come up, I'm happy to answer them. Go to askharry.info.
Great. Okay. I think this has been really helpful. Thank you so much.
Thank you for all attending.
We'll hope to stay well.
Yep. Everybody stay healthy. Enjoy the rest of your quarantine.
Okay. Have a good night.
However long it's going to be. Thank you.
Okay. Night.
Good night.
Good night.